Well, Iowa's fight over abortion laws once again took center stage before the Iowa Supreme Court this morning. Lawyers for Governor Kim Reynolds are hoping justices will lift an injunction on a 2018 law. Lifting that injunction would ban abortions after 6 weeks of pregnancy. Now, to understand how we got here, let's take a quick look back. This all started in 2018 when the legislature passed a measure banning abortions after 6 weeks of pregnancy. Once Reynolds signed the so-called fetal heartbeat bill, Planned Parenthood immediately challenged the measure in court. A Polk County judge stopped the law the following January, citing the Iowa Supreme Court's 2018 opinion that abortion is a fundamental right under the state constitution. But last year, the Iowa Supreme Court reversed that decision. 1 week later, the U.S. Supreme Court overturned Roe v. Wade. Now, in response, Governor Reynolds asked the courts to lift the injunction on her 2018 law. Last December, a Polk County judge took on that challenge, deciding the injunction should remain in place. Governor Reynolds challenged that decision to the Supreme Court, which brings us to today. Local 5's Mary Sugden sat in on today's hearing and joins us with what was argued.
Attorneys representing Iowa Governor Kim Reynolds argue that 6-week abortion ban should be allowed to go into place, given the fact that the state no longer recognizes abortion as a fundamental right under the state's constitution. Attorneys for Planned Parenthood, however, argue that that ban remains unchanged, is unconstitutional, and therefore should remain blocked.
Our argument is that the law that the Iowa legislature passed in 2018 is a reasonable law designed to protect and defend life.
Attorneys for Iowa say the goalposts have changed, saying the 6-week abortion ban was blocked due to previous court opinions that have since been overturned.
The courts have corrected mistakes they made previously in holding that there is a right protected by the state constitution that's at issue here. And now that we have a proper understanding of the state and federal constitution, it's clear that Iowa's attempts to protect life.
Lawyers for Planned Parenthood, however, say what hasn't changed is the Iowa Supreme Court's opinion that the standard to evaluate these laws must determine if it places an undue burden on Iowa's women.
Last year, in the Planned Parenthood of the Heartland 4 ruling, the court left in place the undue burden standard, and the state is trying to challenge that. And so our understanding and the Iowa law right now is that undue burden standard governs, and under the undue burden standard, the 6-week ban is absolutely unconstitutional.
Something that is important to note here is that Justice Dana Oxley recused herself from this hearing. It remains unclear why this decision was made, but it could have a potential impact here on these proceedings. If for some reason we get a 3-3 opinion, that means that this would go back to the lower court and essentially go to that opinion, meaning that what the Polk County judge ruled in December of the injunction remaining in place would be the law in this case. In Des Moines, Mary Sugden, Local 5 News, we are Iowa.